Good morning. This is a time set for oral argument in our case number CV19-0078, Jody Foreman versus Grand Canyon University. And others. Each side is allocated 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal if you wish to do so. If you wish to do so, you'll need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask those in attendance to make sure your phones are turned off. That also will avoid any embarrassment should your phone ring. We've read the briefs and conferenced the case. We're familiar with the record. We'd encourage counsel to keep that in mind as you present your oral argument. Our proceedings are being recorded and will be posted to YouTube. As you begin your argument, please, if you would, state your name and the party that you represent. With that, Mr. Wood, you may proceed.
Good morning, and may it please the court. My name is David Wood of the DeSalis Law Group, and I represent the four plaintiffs who remain in this action, either not set for trial. Plaintiff Brian Peace is set for trial in March of next year. Trial, not arbitration. And Plaintiff Michelle Dudley voluntarily withdrew her claims and exited the litigation. In this matter, there are two bases upon which the court should reverse. The first one is very simple. There's a confession of error to this court in that we raised the issue that was litigated below, that these arbitration agreements are unconscionable, specifically because Grand Canyon University, which I'm going to shorthand to GCU, as most of us say locally, did not abide by that same arbitration agreement with a student in the same program 28 days after informing the court that it considered itself mutually bound. We raised that. We properly supported that with citation and argument, and GCU chose not to respond. The standard in this court is that if we raise a debatable issue and the other side does not respond, that is treated as a confession of error, and this court should do so. So,
what difference does it make if they assess another case and determine in that case they're better off to go to proceed to trial and elect not to enforce the arbitration?
Because then it makes the arbitration clause completely unilateral, Your Honor.
Well, I mean, the other party could have asserted it. And
the other party actually did assert it.
What was the first one?
That part I don't know, because that went beyond and I apologize. When I say asserted it, the other party actually alerted Grand Canyon University in their private correspondence with, hey, we have an arbitration agreement. What are you doing?
If both parties to a contract that has an arbitration provision in it waive that provision, what bearing does it have on any other contract provision in any other contract?
If the parties waive it, it does not have a bearing.
Well, that's why I asked you. It seems to me like GCU waived it in that case, and the other party didn't request that arbitration be enforced.
Well, if a party is part of a mutual arbitration agreement, there is no going to court and saying, I'm waiving it. There is file it in arbitration or ask the other side to agree to waive it and go to court. That's not what happened.
Well, but can't waiver occur in many different ways?
It can occur in many different ways, just not in the way of filing a claim in court, not alerting the court that there is any arbitration agreement, which is part of what are the customary filings in the Maricopa County Superior Court. You have to alert the court whether it is something subject to arbitration. That was not done. So in this instance...
And I still struggle to follow up on with Judge McMurray's question, why that is particularly relevant here.
It's particularly relevant because it occurred less than 30 days after they informed the court against the challenge that this was an unconscionable unilateral agreement. No, we consider ourselves absolutely bound by this. And you can see in the trial court's ruling, in the minute entry ruling, the trial court was relying on statements with, hey, GCU's not acting as a plaintiff.
Let me give you a different hypo, and it's outside of arbitration, and I get that arbitration may be unique enough that my hypothetical won't work. If I'm, say, a rental company, let's say I'm Hertz Rental Car, and I have a provision in a standard agreement that requires a party renting a car to pay a certain fixed fee, and I enforce that 999 times, but in that 1,000th contract, I don't. I waive that. How is that relevant to the other 999?
Well, I think this is where I'm going to have to disagree with the term waiver. There's waiver, which is alerting the court, there is this agreement, we don't want to follow it, we don't think that we have to, and here's why, let the other party make their decision. But the problem, I guess, also with the hypothetical is, how is a litigant to determine whether it's only one time versus 999? There's only so much searching within the court system that a litigant can do.
Let's say Hertz, in my hypothetical, sued 999 times, but didn't sue that 1,000th time.
Right. And if they did not alert the court that there was an arbitration agreement, did not actually put at issue for the other side to agree to it, yes, that makes it unilateral.
One final question, and then I'll let you go on, because you've whet my appetite with that second issue. But does that mean in suing the 999 times in my hypothetical, the rental car company would have to tell the court, oh, by the way, Judge, there's this 1,000th time where we're not seeking to enforce our contract. You need to be aware of that. I'm struggling with that.
If there's a challenge that the contract is in effect unilateral, then there is a duty to disclose that to the court and the other side.
Well, and I'm sorry, I have to follow up again. So you're telling me that if two parties that have a contract that has an arbitration, and the parties are in dispute over a particular part of the law, and so they realize that they need a legal determination, and they realize that if they're not going to get it through arbitration, that they're going to actually have to sue, and so they both say, okay, great, we'll go to court, we'll figure out what the law is as it relates to this particular dispute, and they file. One of the parties files a suit. Wait, can the court just say, no, there's an arbitration provision in the contract, neither party's asserted it, but I'm going to remand it for arbitration?
The court, I think in that instance, should ask the parties, are you both agreeing to waive that arbitration provision for simply a declaratory ruling? But in this instance, what you can see with the lawsuit against Mr. Larson...
So if the party's conduct suggests waiver on the part of both, you're saying it's the court's duty to sua sponte to raise the arbitration agreement?
I think that if one of the party puts it at issue, so I'm not suggesting that the trial court would do it, needs to do it sua sponte. And I guess the difficulty there is, how would the trial court know if there's an arbitration agreement to raise sua sponte?
Well, if it's a matter under contract, somebody's going to hopefully give the court the contract.
Agreed.
And most judges can read.
Oh, yeah, they're fantastic readers. I would never debate that. But in this instance, Mr. Larson's was not a contract claim. In fact, it was very factually specific. He was saying GCU is engaged in fraud, GCU is ripping off students, and I'm not quoting, I'm paraphrasing, is ripping off students, he's trying to incite students. So that was a libel claim, in addition to a tortious interference. That wasn't just, hey, I'm going to issue a legal ruling, is GCU engaged in this? That would require tremendous review of documents. And so what you have in this record, you have record of 3 lawsuits involving students with GCU. Our lawsuit, where there is we have a mutual binding arbitration agreement. You have the lawsuit referenced in Georgia, which is where they moved for arbitration against that. And then you have the one instance where a student where they actually want to shut down a student's speech, and that's instead brought in court. So it's not 999 versus 1. We have 3, and when a plaintiff such as ours want to actually litigate how the program runs, which requires documents, depositions, and such, it's no, we want to shut this down and go to arbitration where there's no discovery. So, and then when we want to actually intervene involving this student, no, we want to go to court right away. And under those circumstances, where those statements were made to the judge, this is a unconscionable, this is an unconscionable arbitration agreement. And you can see actually that the judge rejected, the trial court rejected the GCU's arguments for why they brought it in court. It's just for whatever reason, apparently scorning GCU with "don't do it again" was considered enough, and that's not enough when you have something in front of you showing that one party is not going to abide by the agreement. So with regard to that, also the standard for the court is debatable issue, and we have certainly raised a debatable issue, and there has been no response, and that's treated as a confession of error. So
that's not mandatory. That's discretionary. Was our court,
it is discretionary, but again, I haven't seen anything. I'm not aware of anything that suggests that coming up with something today at oral argument to try to excuse that should suffice when the standards in front of this court, which again are discretionary, are that this court does not hear new arguments and issues at oral argument either. With that, I will move to the borrower defense rule for just a couple of minutes. But what I can tell you is that we do desire a ruling on both issues because the borrower defense rule looks like it's about to be set for more protracted litigation in July of this year. And we, under this standard, should already be in trial because the trial court's basis for not applying the borrower defense rules when they actually came into effect late last year was stating that they're not retroactive. I think that everybody has, I haven't seen an argument from GCU that they are not in fact retroactive as they argued in the trial court, especially when the regulations expressly state these apply to student loans predating the effective date.
Doesn't it require that there be some action taken after the effective date? They're not going to mandate that you go back and every arbitration provision that was ever litigated be undone and redid in court.
Well, if a case has reached a final decision, not necessarily. But if a case has been subject to an arbitration ruling, yes, actually the federal regulations mandated that GCU amend the arbitration agreements for each student to provide notice. We will not rely upon this, and we will not assert this in court. So there was a tremendous remedial order in the federal regulations.
Wasn't that for actions that had not begun? Again, as Judge McMurray points out, where there had been no action initiated?
I've seen nothing in the regulations stating that it only applies for cases that have just started. But in addition, I would suggest if there's that remedial, there's a remedial action that you need to go and amend every arbitration agreement predating July 1, 2017, that doesn't really work if a case is in the pipeline. And I think that one of the most telling aspects of that it is not simply if an action has not begun is that the mandates in the regs, which I'm just going to go off of the last three digits, they're 685, but if you look at section 300, it specifically states what reliance on an arbitration agreement is and what's barred, and that bars, and it's difficult to is rely in any way on a pre-dispute arbitration agreement with respect to any aspect of a borrower defense claim. So reliance can be simply resisting discovery. So when you have them being that specific, that suggests quite the opposite, which is if there is a case going on and the arbitration agreement was used for anything interfering with an actual judicial determination with an exchange of documents, that can no longer happen. With regard to the argument that these are not borrower defense claims, that really just comes down to ignoring the effects of the federal regulations, which are three. There's a triggering date, July 1, 2017, on those regulations. For claims before July 1, 2017, what the Department of Education did is they relied on old state standards. So any claim under state law that met the definition of borrower defense, which then can go to court, not subject to arbitration. And then July 1 in 2017 and after, for those loans that are issued, there's a new federal standard for contract and substantial misrepresentation. And that's what GCU has cited to, which are sections C and D of 685-222. The error there is that the Department of Education was not exempting contract and misrepresentation claims from the arbitration bar. What they did was July 1, 2017 and thereafter for those loans, those claims are governed under the C&D federal standards in an in-house proceeding at the Department of Education. So they weren't exempting something from the arbitration bar. They were actually just stating no arbitration for those loans predating the triggering date, and for those loans thereafter, we don't need to worry about arbitration because you go to the Department of Education for an in-house proceeding.
Let me draw you back to the section 300, which does include, in terms of the reliance, it does include the rely in any way broad language, but doesn't subsection F2 define reliance more narrowly? Seeking dismissal, objecting to or seeking a protective order, filing a claim in arbitration. I guess what I'm wondering is, does that subsection F2 more narrowly define reliance such that GCU has not actually engaged in any of the conduct there so as to rely on, to be in the category of reliance?
Well,
prior to the or after the effective date.
Well, the GCU did. They sought dismissal for compelled arbitration. So now it might not have been after the effective date was actually July 1, 2007, was July 1, 2017. Now that was stayed, but this complaint was filed July 11, 2017. And that's how also this court can know that the loans at issue are...
But if the effective date is stayed, don't we look at the effective date that it actually comes to fruition, not the effective date that was originally proposed?
I think that the court's lifting of the stay cannot alter that language. So the effective date is...
And that may be true, but it can alter the effective date.
It can. I think that's where we get into a difficult thing of what are we saying by effective. So by lifting the stay, it's simply saying something that should have gone into effect is in fact there. But I don't think that that's necessary.
If it was stayed, it did not go into effect. That's the definition of a stay, isn't it?
Right, it is, and it was stayed until that date at last fall. But it doesn't change that the reliance might have specific. It might have specific examples, as you were saying, Your Honor, in small section 2, but that's all introduced with the paragraph up at number 2, which is includes but is not limited to. So that those are specific examples, but when specific examples don't resist discovery.
So what is the conduct that GCU engaged in that constitutes reliance after the actual effective date, taking into account the stay?
The conduct after the stay would still be that we're in arbitration where no discovery was happening whatsoever, and that was something that we cured before the trial court on the motion to reconsider. So, but I don't believe that this court needs to find specific conduct after the effective date after the stay. The court should simply go off of the regulation dates. Because again, that's also something that I have not seen GCU raise as an issue in this litigation.
Doesn't that mean that the stay was illegal?
I think that the stay met its purpose, which was kept things at the status quo ante until the court could resolve all of that.
If it kept the status quo, then don't we have to look when it began?
I think that, if the court looks at when it was effective, these students were being in compelled arbitration with AAA arbitration with no discovery. So it doesn't change when the order was. They were stuck there based on a motion to dismiss for those arbitration agreements, which, by the way, after that effective date, were supposed to be amended so that they could go to the court or the arbitrator with that there should be no compelled arbitration. So with that, I'll reserve my last 50 seconds of time.
Thank you, counsel. Mr. Dickerson.
Good morning, and may it please the court. My name is Deeran Dickerson, and I represent Grand Canyon University and Grand Canyon Education, Inc., the appellees in this matter. Grand Canyon urges the court to affirm the decision below because the trial court was well within its ample discretion to deny the motion for reconsideration for at least two independent reasons. First, the motion was untimely. And second, the Department of Education regulations cited by plaintiffs do not apply to plaintiffs' claims in this lawsuit. Trial courts have broad discretion in ruling on motions for reconsideration, including under Rule 60B. And the trial court here simply did not abuse its discretion. As the Supreme Court of Arizona has confirmed, trial courts are in a better position to balance the issues on a motion for reconsideration. And this court should not reverse that decision unless there is clear abuse of discretion. And here,
Well, if we're talking about what amounts is to clear legal error, we're looking at statutes and rules. What abuse of discretion is there?
thank you for that question. There's discretion with respect to the timeliness of the motion for reconsideration itself. And the legal question is the application of the borrower defense regulations. In fact, I think the decision can be upheld on that ground as well. But with respect to the timeliness of the motion, the court held that it was out of time because the court had ruled on the underlying motion to compel arbitration over a year before plaintiffs filed their motion to compel or motion for reconsideration. The court also noted.
Is that a legal conclusion?
Is it a legal conclusion that they filed it 13?
We know when they filed it. The legal conclusion is whether it was timely.
I think that's a matter of discretion within the. The rules themselves say that a motion for reconsideration has to be filed within a reasonable time. A reasonable time isn't defined in law. It's subject to the discretion of the trial court. And I think it's particularly relevant in the context of a motion to compel arbitration because the parties are off arbitrating the underlying dispute.
Now, the basis, though, the sort of the ripeness of the reason for the motion for reconsideration didn't come to fruition until the 2018 regulations. So looking at that time frame, that was what, about 22 days from implementation of the regulations. So wouldn't we say that's an abuse of discretion to say that that 22-day period rendered something untimely?
I wouldn't say it's abuse of discretion for two reasons. One, really that 13-month time frame is important in the context of arbitration because the arbitration proceedings have already commenced. And in fact, the arbitrators had scheduled arbitration hearings to begin shortly thereafter. Second thing that I would say is that it was closer to 2 months after the district court in D.C. issued its decision lifting the stay. And the lift of the stay was effective October 16, 2018, but the underlying decision was in September, and the plaintiffs didn't file their motion for reconsideration until November of 2018. And the reason that's important, as the trial court articulated, was that these arbitration hearings were upcoming soon, and giving the briefing schedule and the time for the judge to consider the motion for reconsideration, they'd be on the eve of the arbitration hearings by the time any decision was rendered.
Fair, but the arbitration hearing hadn't happened, right? Isn't your case far stronger if you've already gone to either hearing or award as opposed to ramping up for hearing or award?
It would certainly be stronger if arbitration had already concluded or if the hearing had already began, but the proceedings had begun. The parties had already engaged in the preliminary process of arbitration, and Grand Canyon had paid the arbitration fees that it otherwise would not have had to pay. So there was some significant harm and prejudice to the parties.
Here, with respect to the regulations, though, given the federal stay, You're not arguing that the plaintiffs should have sought to enforce them during the pendency of what I rather gather was a nationwide federal court stay? You're not making... Oh.
I'm not making that argument.
Okay.
I
All
would
right.
suggest that they didn't have to wait 2 months after the district court's decision, but yes. It's more the prejudice that exists because of the 13 months after the court had already dismissed their claims and sent the parties to arbitration. So the court can affirm the trial court's decision on that basis alone because the trial court properly exercises discretion in denying the motion for reconsideration. But the second issue perhaps is even more compelling because it is in fact an issue of law, and it's a clear issue of law. The borrower defense regulations simply do not bar the claims at issue in this lawsuit. Obviously, this was not the basis of the trial court's decision, but this court can affirm a decision if it's right for any reason. And it was certainly right here because the borrower defense regulations simply do not apply. I think a little bit of context may be helpful. The borrower defense regulations were implemented by the Department of Education to permit student loan borrowers to raise defenses to paying back their student loans to the federal government. These regulations are called borrower defenses. In 2016, the Department of Education established a new federal standard to determine whether a student has a defense to paying back his student loans or her student loans. And at the same time, the Department of Education amended its participation rules for schools that are participating in the federal direct loan student program. And so each school has to execute what's called a PPA, a program participation agreement. And that agreement governs the relationship between the school and the Department of Education. And it was that amendment that required schools who participate in Title IV not to enforce pre-dispute arbitration agreements for certain claims that the department called borrower defense claims. Now, here's
Mr.
where...
Dickerson, can I interrupt you just for a second, because I just want to make sure I'm clear. So, prior to the implementation of the regulation at issue, was there anything that would prohibit a school from having an arbitration provision in their contract with a student?
There was not. And in the discussion with my colleague, that revealed one of the flaws in their argument, because prior to 2016, there was no prohibition in using pre-dispute arbitration agreements. It was only the 2016 amendments that required or that prohibited schools from relying on pre-dispute arbitration agreements with respect to what the regulations called borrower defense claims. And I understand it's a little confusing because the department used similar terms to describe two similar concepts, but they are in fact very different concepts. Borrower claims, on the one hand, is defined in 685 222A, or 222A through D, whereas borrower defense claims are defined in 685 300F. The terms are similar, but they have different meanings. Borrower defense in 222 is broad. Borrower defense claim in 300 is much more limited. To be sure, the definition of borrower defense claim in 685 300 excludes the very claims at issue in this litigation. It defines a borrower defense claim as one that could be asserted as a borrower defense as defined in 222A5, which is the broad definition, including a claim other than one based on 222C or D. It's clear from the plain text of the regulation itself that there is a distinction in the definition between the two terms, that borrower defense is broader than borrower defense claim. And it does not include a claim based on 222C or 222D, which are claims based on breach of contract or substantial misrepresentation, the exact types of claims at issue in this litigation. Plaintiffs would suggest that the court read the term other than as inclusive rather than exclusive, but that simply belies logic. If someone said you can have all of the cookies in the cabinet including the Girl Scout cookies other than the Thin Mints, any reasonable person would understand that that excludes the Thin Mints. It doesn't include them. And the court should reach that same conclusion with respect to the language in the statute here. Critically, the claims the department excluded from the definition are breach of contract and misrepresentation, and there's no dispute that those are the precise claims that plaintiffs bring here.
So are you telling me that today, if students from GCU were to bring the same action today based on a contract that was entered prior to the amendment, that you could still assert a pre-arbitration provision, pre-dispute provision of arbitration under the current regulation?
Yes, because those claims, assuming they are claims that fall under 222C and D, they're not borrower defense claims as the statute defines them, or the regulation defines them. And it's only 685-300 that defines the types of claims that are subject to the pre-dispute arbitration ban. And to plaintiffs' argument about pre-2016 claims and post-2017 claims, that has no bearing to the issue, because that only defines the standard that the department uses in evaluating borrower defenses based on the time frame in which the student received the loan at issue. But in terms of the regulation that bans pre-dispute arbitration agreements, it only applies to a limited set of claims as defined in 685-300F.
But the way I read the regulations, you couldn't put a pre-dispute arbitration clause in your contracts with students today.
I would disagree with that. You can put a pre-dispute arbitration agreement in your contract with students as long as that doesn't apply to borrower defense claims. So if it's a borrower defense claim, Grand Canyon cannot enforce its pre-dispute arbitration agreement with respect to those claims. So for example, under 685-222A, claims relating to certain state requirements that may not rise to the level of a substantial misrepresentation for which a student reasonably relied, that is a borrower defense claim that would be subject to the ban on pre-dispute arbitration agreements. But the claims at issue here that fall under 222C and D are not borrower defense claims, and the definition and the regulations clearly exclude those from the ban. This court should follow the Northern District of Georgia's decision in Carr versus Grand Canyon, which is the only case to address this issue. And because the language is clear and unambiguous, the analysis ends and the court should affirm the decision below. But even if the borrower defense regulations somehow apply to the claims at issue here, and they do not, it doesn't prohibit enforcement of the arbitration agreement. Because as I mentioned earlier, the regulations relating to the pre-dispute arbitration ban fall within the regulations that define the relationship between the school and the Department of Education. And the department itself has said in the litigation that my colleague referenced that it's not an impediment to enforcement of an arbitration agreement. It's just a condition to participating in Title IV. And so at the end of the day, this court can only make the determination, or any court can only make a determination as to whether the claims are in fact borrower defense claims. This court's responsibility is not to then invalidate what is a valid arbitration agreement. It would then be incumbent upon Grand Canyon to decide whether it wants to continue participating in Title IV under the regulations that the department has set. Notably, and obviously this hasn't gone into effect yet, but the Department of Education doesn't stand behind these regulations and in fact has amended them so that schools going forward will be able to continue to assert its right to arbitration under pre-dispute arbitration agreements for all claims, including borrower defense claims.
But those regulations don't take effect until July 1st.
That's correct. That's correct. Absolutely. I do want to mention the retroactivity issue because plaintiffs misconstrue the regulations relating to retroactivity. Of course, the regulations do apply to loans that were taken out prior to the effective date of the or the enactment of the regulations. But what they don't do is go back and apply to arbitration proceedings that are already ongoing. As the court indicated, it would be absurd to force parties to go back to court after they've already arbitrated their claims. And there's nothing in the regulations that indicate that they apply to arbitration proceedings that have already taken place. Grand Canyon has not relied on the pre-arbitration arbitration agreements as that term reliance is defined in the regulations itself. Because at the time Grand Canyon sought to compel arbitration, the regulations weren't in effect. They simply did not apply to any claims at that point. So even if they applied to the claims at issue, they weren't in effect when Grand Canyon relied on the pre-dispute arbitration agreement. And lastly, I'd like to address the confession of error issue. As the court rightly noted, the doctrine is discretionary. And the court should not reverse a trial court's decision based on an implied confession of error when the trial court's decision, in fact, was correct.
Wouldn't it have been simpler if you'd have just included a response to the argument?
It would have been simpler, Your Honor. But I would say that the issue is not debatable. The clear language in the arbitration agreement shows that it is mutual. It clearly says that both the school and the student are required to arbitrate their claims against one another. With respect to the Larson litigation that Grand Canyon filed, it was a case relating to harassing conduct by that particular student. He was harassing professors and faculty members, and Grand Canyon sought a preliminary injunction against him. The AAA rules clearly say that the parties to an arbitration agreement can request interim relief from a court without waiving their right to arbitrate their claims. And in fact, Grand Canyon in that litigation noted time and again that all of the other claims were subject to arbitration, only its preliminary injunction should be decided by the trial court. And so there's simply no issue of lack of mutuality, even if that could somehow undo a valid arbitration agreement with respect to unrelated parties. I think it's clear from the statutory interpretation that these claims are not subject to the pre-dispute arbitration ban, and we would urge the court to affirm the decision of the trial court. Thank you.
Thank you, Counsel. Mr. Wood, rebuttal.
Thank you, Your Honors. I'm actually going to proceed backward. It's rather incredible that there was just a statement that GCU sought a preliminary injunction on a record that demonstrates they never sought a preliminary injunction, and where we outlined that the suggestion that they could preliminary enjoin speech is a First Amendment violation. That did not happen, and again, that's also a brand new argument being raised today, as is the argument that retroactivity is simply absurd, which is a Department of Education decision, which they made, and that Title IV participation limits this court's authority with regard to what it does, also not in any brief. So, and beyond that, what I would note is that Section 300 C and D is not definitional for all borrower defense claims. It's but definitional for loans issued July 1, 2017 and thereafter. That's why Section 300 had the arbitration bar, because everything predating July 1, 2017 goes to court under state law standards that remain. Thank you.
Thank you, Counsel. Counsel, we appreciate your argument this morning. We appreciate your briefing. You've given us much to think about. We'll take the matter under advisement, issue a written ruling in due course. We'll stand in recess until the courtroom is set up for our next oral argument.